Alright, so today we're going to be talking about the criminal law process. Yesterday we talked about criminal law, which again talks about the law being broken. Somebody was harmed and someone has to be punished for doing harm to someone else or to someone else's property. So what is the criminal law process? It's how a case goes from a broken law to the enforced consequences. So, how you break the law like a boss, like this seagull here is doing, all the way to your sentencing, to your consequences. This could be in prison, this could be with community service, with probation. Doesn't necessarily have to be prison, just so you know. So, some review of Unit 6 before we start. There's two sides to the case, and the plaintiff is the one that's making the complaint. If you look at the word complaint and you put IFF at the end, right over here, you'll see plaintiff. So remember, they're the one that's making the complaint, accusing someone of a crime. The defendant is the person that is accused of the crime, and they are defending themselves. Or, rather, you would hope they would have someone to defend them. So the prosecutor is the person who represents the government, not necessarily the plaintiff, but the government in the case. This is usually done by the district attorney or a representative from his office, another lawyer. And they are against the defense, who represents the defendant. So defense and defendant go together, and the prosecutor is representing the government. It sounds simple, but there are 8 stages in the process. But don't worry, there's an easy way to remember them. So our first step in the criminal law process is probable cause. This is a strong chance that someone has broken a law. However, like we learned yesterday, presumption of innocence tells us that someone is innocent until proven guilty. Now, whether the public thinks that you're innocent or proven guilty, or the media thinks that you're innocent or proven guilty, not necessarily the case. However, in the judge's and the jury's eyes, you are innocent until you're proven guilty. So probable cause could be a police officer walks by someone's car and smells a strong scent of marijuana and decides to follow up and further investigate. This could also be that someone who looks a lot like you has been spotted on camera at the local Handy Mart. And it could be that the police officer thinks that you look like enough like that person to try and hold you until they can get, number 2, a warrant for your arrest. So the first step is probable cause, and the second step is arresting the person. And the police have to get a warrant to arrest someone unless the person resists arrest or will not go willingly with the police. And the suspect will be arrested and informed of the charges against them. So, like Amendment 4 says, you have to have a warrant, and there is no illegal search and seizure. So that could be seizure of evidence against you or yourself, actually. So they have to get a warrant, and the suspect is going to be arrested and informed of the charges against them. And remember, our Miranda rights tell you that you've got to be informed of your rights as well. So, you've got the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney, and if you cannot afford an attorney, cough cough, Gideon versus Wainwright, one will be provided for you, usually they add here, by the state of North Carolina. So moving on to step 3, booking. A suspect is taken into custody officially and charged with a crime. You're no longer known as a suspect at this point in time. You are now known as a defendant. So you'll have your lovely little mugshot taken, like these Santas over here, and you will have to fill out paperwork from the magistrate's office of whatever county you are in, whatever county you've been accused of a crime in, and you will be formally charged. Well, it'll be a pending charge technically, but you'll be formally charged with a crime. Remember, this third stage is booking. And now we move on to our 4th one, which is the preliminary hearing. These next few steps are going to take place in a courtroom. Until now, you have been part of the order, part of law and order, and now you moved on to the law part. So number 4 is the preliminary hearing. A defendant is brought before the judge and learns more about the charges against them. So here, the judge might explain, well, sir, do you know why you were charged with this? Or, well, ma'am, do you know why you were charged with this offense? And your lawyer hopefully will answer for you and say yes or say no, and you will learn more about these charges and what exactly it entails as far as sentencing goes. And the judge sets your bail requirements based on the case and the defendant. So if the judge looks at your rap sheet and sees that it is a mile long, he might set your bail higher than he set someone else's for the same crime. So let's say that John Doe goes in the courtroom and his rap sheet is about a mile long, and he has been arrested for assault and distribution of narcotics and all kinds of other things, and more simple assaults, because this John Doe can't seem to stay out of bar fights. And let's say that they're arrested for assault. The judge might set his bail requirement at $15,000. And let's say that Jane Doe walks into the same courtroom later on in the day, and she only has one offense on her record. Let's say that she only has one speeding ticket. Her bail might be $2,000 because it's based on the defendant. It's also based on the case. So if you steal a pack of gum from the Handy Mart, you're going to have less bail than someone who has been accused of murder or armed robbery or prostitution or some other more serious crime. So misdemeanors, the less intense crimes, are going to have smaller bail requirements than felonies, which are more intense crimes. So what exactly is bail? It's money to ensure that the defendant returns to court. So if you would like to be released into society while you wait on your court date after you are charged with a crime, you may do so. You can pay the court money. So let's say that you have been issued bail of $5,000 and your court date is, I don't know what's today, April the 11th. Let's say your court date is in May. So let's say May the 4th. So let's say that you have until May the 4th, and you pay your $5,000, and you return to court on May the 4th. You get all of your $5,000 back. If you do not return to court on May the 4th, your court date, you will not receive your $5,000, and in addition to that, you're going to be charged with failure to appear in court. So on top of the crime you're already charged with, you get another one for failure to appear in court. So this bail money is collateral to make sure that you get your tail to court on time. Our fifth step in the process is indictment. And I put in parentheses grand jury here, because you need to know that there is a grand jury here. A grand jury decides if there is enough evidence to take the defendant to trial. And a grand jury is bigger than a petite jury. Okay? Petite jury is made of 12 people, and a grand jury only happens in federal cases. So if someone is in federal district court, if you have murdered the president, you are going to get a grand jury who is made up of more than 12 people to decide whether or not you've got enough evidence to be put on trial for whatever crime you have been accused of committing, like murdering the president. Okay? Our sixth step is arraignment. A defendant is informed of the charges against them and pleads either guilty or not guilty, and you have to prove this at the trial. Okay? So, your arraignment, you are even further informed of the charges against you, and you can say, yes, I plead guilty, and not have a trial at all, or not guilty, and take this to trial. Here we have OJ, who says he's not guilty, or guilty. Either way, it's up to you, your personal opinion. So a side note, a writ of habeas corpus, this should be review, you must inform a person of the charges against them. Habeas corpus means to produce the body in Latin. So you've got to be able to produce the charges and tell someone why they are charged with the crime. Or what charges they are charged with. What crimes they're charged with, excuse me. Our other side note for this box is a plea deal. So a defendant can plead guilty to a lesser crime to get a lesser punishment and save court time. So let's say that you've been charged with armed robbery. Let's say that you make a plea deal, I'll plead guilty to breaking and entering instead of armed robbery. And instead of getting 10 years for armed robbery, if I plead guilty to breaking and entering, I only get 3 years in prison. So I save my self-court time and I get a lesser punishment. Our seventh step in the process is trial, and here you pick a jury. It's a long process because remember you have the right to an impartial tribunal, which means that you have the right to an unbiased group of people in the whole judicial process. So you've got to make sure you pick a jury who doesn't know who you are, doesn't know any of your family members, people that are going to be unbiased. They also try to pick a jury that is culturally and racially diverse. So you can't have a jury of all women, or you can't have a jury of all men, or all old people, or all black people, or all white people. They have to make sure that their jury is fair, unbiased, and culturally balanced. And in this trial, you've got a couple different things that go on. You have your opening statements, and then both sides present their cases. They question each other. They have closing statements, and then they reach a verdict. And the petite jury happens here. This is the trial jury, and they actually reach the verdict. So when the judge asks the lead juror, how do you find the defendant? That is a petite jury. That's the leader of the petite jury, those 12 people who says, we find the defendant either guilty or not guilty. Here's a scene from My Cousin Vinny, one of my favorite movies. It's really funny.
Ms. Vito, please answer the question. Does the defense's case hold water?
No. The defense is wrong.
Are you sure?
I'm positive.
How could you be so sure?
Because there is no way that these tire marks were made by a 64 Buick Skylark. These marks were made by a 1963 Pontiac Tempest.
Objection, Your Honor. Can we clarify to the court whether the witness is stating opinion or fact?
This is your opinion?
It's a fact.
I find it hard to believe that this kind of information could be ascertained simply by looking at a picture.
Would you like me to explain?
I would love to hear this.
You cannot sit on the table in court, just saying.
These two equal-length tire marks had positive traction. Can't make those marks without positive traction, which was not available on the 64 Buick Skylark.
And why not? What is positive traction?
It's a limited slip differential which distributes power equally to both the right and left tires. The 64 Skylark had a regular differential, which anyone who's been stuck in the mud in Alabama knows. You step on the gas, one tire spins, the other tire does nothing. That's right.
Is that it?
No, there's more. You see, when the left tire mark goes up on the curb and the right tire mark stays flat and even, well, the 64 Skylark had a solid rear axle. So when the left tire would go up on the curb, the right tire would tilt out and ride along its edge. But that didn't happen here. The tire mark stayed flat and even. This car had an independent rear suspension. Now, in the 60s, there were only two other cars made in America that had positive traction and independent rear suspension and enough power to make these marks. One was the Corvette, which could never be confused with the Buick Skylark. The other had the same body length, height, width, weight, wheelbase, and wheel track as the 64 Skylark, and that was the 1963 Pontiac Tempest.
And because both cars were made by GM, were both cars available in metallic mint green paint?
They were.
Thank you, Ms. Vito. No more questions. Thank you very, very much. You've been a lovely, lovely witness.
Alright, so that's part of My Cousin Vinny. That's part of the trial. Number 8 is sentencing. This is done after the defendant is found guilty, usually pretty soon afterwards. This is based on the Penal Code, which outlines crimes and the punishment for breaking these laws. So this outlines what the sentences would, or the punishment would be for robbery, or simple assault and battery, or breaking and entering, or stealing a car, something like that. So again, this is the Penal Code, and sentencing is based on that, and this is done after the defendant is found guilty. So if you're found not guilty, you are not sentenced to anything. There's two kinds of sentencing. Indeterminate sentencing, it's got a maximum and a minimum, and the judge and the jury decides. And mandatory sentencing, where the judge sets the punishment and there is no wiggle room. So indeterminate and mandatory. And our last spot on note is parole versus probation. Parole means a prisoner is released to serve the rest of their sentence out in the community. And probation means that the prisoner is supervised in the community instead of going to jail. So parole, you've already been to prison and you're serving out the rest of the sentence in the community. That's the worst of the two. And the less intense of the two is probation.